This employment law video is on exit strategies. There are different strategies for leaving employers. The appropriate strategy will depend on the individual's circumstances. In some cases, an employee may simply wish to resign to pursue other opportunities. In other cases, though, an employee could have a falling out with their boss. There could be harassment, for example, or bullying, or someone is overlooked for a promotion, or there are unfair performance ratings. In these situations, what are the choices? Lodging a grievance. In some situations, you may wish to lodge a grievance. Usually you'd be required to try and resolve the matter informally first. This could mean having informal discussions with HR involvement. If, however, the matter is not resolved, it may be appropriate to raise a formal grievance. You should normally have raised a grievance before bringing an employment claim. While there's no legal obligation to have raised a grievance beforehand, compensation could be reduced by up to 25% if you've acted unreasonably in not submitting one. Reaching a deal. In some situations, it may be possible to reach an exit deal with your employer. It may be possible to have what's called without prejudice off-the-record discussion to try and reach a deal. Each case, though, will be different, and it's important for you to obtain legal advice before starting those discussions. Usually, if a deal is reached, the parties would enter into a settlement agreement, whereby an employer may offer a sum of money on the basis that the employee waives their rights to bring certain claims. It is a requirement for settlement agreements that the employee obtains independent legal advice. The advisor will need to advise the employee on the terms of the agreement and the employee's inability to pursue employment claims. Pursuing a claim. Depending on the circumstances, you could consider bringing a constructive unfair dismissal claim. For constructive unfair dismissal claims, you would need to have resigned swiftly as a result of a fundamental breach by the employer. This could be, for example, the breach of the implied term of trust and confidence. It's not easy to bring a constructive unfair dismissal claim, and you should certainly obtain legal advice before resigning and at the earliest opportunity. Before bringing a claim, you would need to follow ACAS's, that's the Advisory, Conciliation and Arbitration Services Early Conciliation Process. The claim must usually be filed in the employment tribunal within 3 months less a day from when the employment ends, and that's subject to the rules for extending time for early conciliation. You could have other claims too, such as for discrimination. That's my video on exit strategies. The usual caveat is that this video is for guidance only and should not be relied upon for specific advice. For more information, visit my website, and if you're interested in receiving notifications on other employment law videos, do subscribe to my channel.